Hello, my name is Alan Bonney. I'm an attorney, and I'm glad to be able to present today about minor guardianships, the process and the procedures, especially in Spokane County, Washington. This program is being offered through the Spokane County Bar Association Volunteer Lawyer Program. My purpose is to explain the court and legal process to obtain a court order appointing a guardian for minors. Now, a minor is a child who is younger than 18 years old. This presentation does not include all of the answers. In my experience, every case is different, and yours certainly will be different based on your experiences and the needs of the child and the interests of the parents. I am not here to provide legal advice. As a disclaimer, the information I'm providing is based upon my reading of Washington Law, Revised Code of Washington 11.130. The opinions I'm offering and the interpretation of rules and statutes that I'm offering today are mine and should not be attributed to the Spokane County Bar Association. Hopefully, the information will prevent most of you from making numerous, not very productive trips to the courthouse. What I have seen many times is individuals going to the courthouse, trying to find somebody who can give them appropriate forms, getting some minimal instruction, and leaving with the thought that all they have to do is fill out the forms and they will automatically receive an order of guardianship. That's really not how it works. On the screen, you should see a minor guardianship orientation page. I plan to discuss many of the required forms to initiate and obtain a guardianship for minors throughout this presentation. Most of those will be put on the screen in front of you. However, the best approach for you as a listener is to have all of the forms in front of you so you can look at them as I discuss them, because many of the forms are multi-page. Don't be confused when you see a checklist with many forms on it. Most of those forms are not needed. There are so many different types of guardianships and situations in which people find themselves that the forms are almost all possible forms that might be needed, but not any guardianship requires every form. Remember that completing forms does not guarantee an order for minor guardianship. A guardian of minors stands in for the parents, providing support, care, protection, education, etc. The state is very protective of parent-child relationships. Now, sometimes a power of attorney is adequate, and I will refer you to WashingtonLawHelp.org now and in the future to answer questions about powers of attorney. One of the major limitations of a special power of attorney by a parent granting a power to what's called an attorney in fact, like a quasi-guardian, is that the reach of a power of attorney is fairly limited and they are revocable. So if a parent decides they don't want the person with custody of the child under the power of attorney to do something the power grants, they can revoke the entire power. Let's return to the minor guardianship orientation. There are basically two types of minor guardianships. One is an emergency minor guardianship, and the other is sometimes called a regular minor guardianship. The forms that you may have in front of you or may look for later can be found at WashingtonLawHelp.org. Click on Family Law, More Topics, and then click on Guardianship. The value of this website is that it includes detailed instructions for completing guardianship forms. Forms are also available at the Spokane County Bar Association in the county courthouse on West Broadway, in the courthouse annex on the 4th floor, which is also where the volunteer lawyer program is, and at the Family Law Center in the Spokane County Courthouse on the 2nd floor. And now, looking at supplies to help you stay organized, I recommend file folders, at least 5. That would include the blank forms that you start with, drafted forms which have not been filed forms after they have been filed, extra copies of forms, and a file folder for evidence documents such as birth certificates and also proof of service and records supporting need for minor guardianship. I also recommend using Post-it notes or paper clips, a pen with black ink, and a pencil to work on the forms. Further suggest a notebook for contact information and further instructions, and a calendar of appointments and court dates, plus instructions and the checklist from the Family Law Center also included with this presentation, 1 for each court file number, in other words, 1 for each child. Each document must be printed only on one side of a page if you plan to file it. Keep copies of all documents. That's one of the reasons for the file folder. I want to direct you to the Minor Guardianship Checklist, page 2 of 4. This is a 4-page document which can be obtained from the Family Law Center at the Spokane County Courthouse on the 2nd floor. Look particularly at the top of the page because I want to talk about emergency minor guardianships and then a subset of emergency minor guardianships called immediate emergency guardianship. Emergency minor guardianships are not required unless the child or children are in such a situation that there's an immediate need for someone to care for them. The immediate emergency guardianship is required when there is a risk of imminent harm to the children. Page 2 of the checklist, at the top, lists the 2 forms that are necessary. The motion for immediate order, emergency guardianship, and restraining order, GDN M204, and the immediate order and hearing notice, GDN M205. You notice the words in parentheses after the word order, EXPARTE, that's usually pronounced ex parte. Read carefully the motion for immediate order, first page. About the middle of the page, in a black outline box, it says, to the person filing this motion. That will give you very detailed instructions about the process. Remember, you will need to go to the county clerk's office, the Superior Court clerk's office, to obtain the file case number and probably the motion and order waiving a filing fee. So follow those instructions very carefully. As I said in the beginning, we want to reduce the number of less than productive trips to the courthouse. Notice on page 1 of 7 that parents need to be served within 48 hours of the judge signing the immediate minor guardianship order. When the parents are served, a proof of personal service needs to be obtained and later filed with the court. There are basically 2 types of guardianships, as I said earlier. One is the emergency minor guardianship, and again, as a reminder, see WashingtonLawHelp.org for copies of the forms and for instructions. The forms are also available at www.courts.washington.org. wa.gov/forms. There are many, many forms in that file. I found the guardianship forms a long ways down from the top, starting with the letters GDN, Golf David November. To begin an emergency minor guardianship requires a petition, as you'll see at the top of page 204. That is GDNM, like Mike, 202. Read through the form completely first, and then you might consider filling it out in pencil to begin with. Work through it carefully. The instructions from the Washington Law Help are fairly complete, and at the same time that you complete the petition, also complete in pencil the emergency minor guardianship order. You'll also need to complete the notice of hearing, GDNM 201. Letters of guardianship are issued by the Superior Court Clerk's Office. There is no form that you fill out for those. There is an additional form called Acceptance of Appointment, GDN ALL003, and that is completed but not presented to the court clerk until the letters of guardianship are issued. Let's talk now about the actual process of obtaining the order that you want, the emergency minor guardianship order. You've completed the petition. What do you do with it? You take it along with a notice of hearing to the clerk's office, third floor of the county courthouse, and walk up to the cashier. If you are a relative, close relative, grandparent, and so on, you should not have to pay a filing fee. However, and they will probably ask you to complete a motion and then a draft order for a judge later to sign, waiving the filing fee. The purpose of standing in front of the clerk is to have a case file number stamped on the front page of the guardianship petition, as well as the notice of hearing. The clerk will also, when you obtain the filing number, give you a 3-page form that's labeled at the top, Confidential Information, CIF. This is not something that is filed. It is something that the clerk asks you to complete, providing detailed information about the parties, who the proposed guardian is, who the parents are, who other pertinent individuals are, information about the child, who is living in the same household as the child will be living, and so on. After this confidential information form is completed, it should be returned to the clerk's office. That clerk is also supposed to assign a particular judge or commissioner and a hearing date. As I said, completing the forms is not a guarantee of obtaining a minor guardianship. That is up to a judicial officer to determine. Your role at this point is to complete the forms in a way that communicates to the judge or the commissioner who the interested parties are and why you think a guardianship is necessary. Remember to be very factual in dealing with the court and what you write on the forms. Service goes to both parents at a minimum, plus any individual with whom the child may be staying, and then for each individual who is served, a proof of service form must be completed. That is GDN ALL007. What does proof of service mean? It means that the person who is providing copies of the petition and the notice of hearing is 18 years of age or older and not a party, which means you're the petitioner and the proposed guardian. You cannot serve the parents. After the court signs the order of guardianship, the court clerk should issue letters of guardianship within a week. You will need to complete and file the acceptance of guardianship form, and you'll need to pay about $6 for the certified copy of the letters of guardianship. So, who is going to see those letters? Generally, they are necessary to show the schools the children are attending, and especially doctors' offices. Anyone who might need to see that the petitioner is now the guardian, assuming everything has gone well, and the petitioner now has succeeded in obtaining a judge's signature on the order for guardianship, in this case, emergency guardianship, and assuming that you have now obtained the letters of guardianship, we turn next to the process of obtaining a regular guardianship. Look at page 3 of 4 and read the procedural instructions. I'll go through some of them very briefly. 1, if you're going to complete forms, make a copy of your own, because once you file a document, you're not going to get it back. In fact, Spokane County takes the originals, scans them, and shreds them. The only time you'd be able to see that document again is through looking them up in the electronic file. Better to have your own copies. After the parties are served, file the proof of service or declaration form, or wait to file that later, but keep it safe. Lastly, regarding procedural instructions, note number 10 that the Spokane County Superior Court documents can be filed electronically. However, if there is a mistake on them, you can't take them back and fix it. Better to take them down and have them reviewed by the court clerk's staff and correct any obvious mistakes before they are filed. When I say a mistake can be identified early, I mean that the clerk can provide information about a required box not being checked, but that you're the only one that can check the boxes. And the clerk can't query you and give you advice about what boxes you should check, which is why this whole process can't be done in an afternoon. You need time to think about the child's needs. Court likely will ask you, how are you going to provide for medical care and education and housing and food and clothing? All the details that a parent would be required to provide. Looking at the minor guardianship checklist, which is page 1 of 4, you will see toward the top underlined general documents needed for all minor guardianship petitions. I'm going to number these for you in the order in which I think it's most productive for you to think about this as a process, short of just filling out forms. When you file the summons and the petition and the declaration, you will want to have a motion and declaration and order waiving a filing fee, which is going to be provided by the clerk's office. It says it in the parentheses. The case cover sheet will be provided by the clerk's office. So, number 1, summons. The practice tip for summons is to be sure to complete on page 1, where it says county of blank, insert the county in which the petition is being filed, presumably Spokane. On page 2 of the summons, which is GDN M001, you notice about halfway down the page on the left, there is a line that says, response shall be made to. You have to fill in the court's name and address. Failure to do that is a defective summons, and it would be a shame to move 6, 8, 10 weeks into this process and then discover the summons was ineffective and have to start that over again. The county courthouse address is Spokane County Courthouse, 1116 West Broadway, Spokane, Washington, 99260. On the right side is directly across from the address of the courthouse is a place for the petitioner. The second form is the Minor Guardianship Petition. It is GDN M102. You might note that if this is a form that you are retrieving recently from the WashingtonLawHelp.org website, it has been revised and the current form is dated 01/2024, so January of 2024. Complete the caption with the name of the county, the name of the child or children, and the court number, and then be sure to check the box Clerk's Action Required, and probably box below that says No Fee 26, and they are referring to, on page 11, item number 26, which says no fee shall be charged because the proposed guardian is a relative of the children and not a professional guardian. However, if the petitioner is not a relative, then a filing fee will be required. The bottom half of page 1 of the Minor Guardianship Petition helpfully lists some of the forms that I've already mentioned. Notice it talks about, or mentions a notice of hearing, the summons, which we've gone into, that was form number 1 on the checklist that has been on the screen. Third item is called Reasons for Minor Guardianship. In fact, the title is actually Declaration Explaining the Reasons for Minor Guardianship Petition. At the bottom, it asks for the name and age of each of the children. Page 2, put in the petitioner's contact information. And sometimes two individuals will want to be co-guardians, and at this stage of the process, they are co-petitioners. So check the boxes for number 2. 3 is just check the top box typically. In my experience, usually the individuals I speak with are the petitioners who are asking to be guardians for the children. We've mentioned about lay guardianship training. This is a box to check saying that you've completed or will complete. Number 5 is particularly important, so I'll spend a bit of time on it. Some guardianships are created with the agreement of the parents. If that's true, then check the top box, Agreement, and on the last 2 pages of this minor guardianship petition, the parents will sign acknowledging their agreement. The second item is termination, and that occurs occasionally. That's where the parental rights have been terminated. I might mention here that some parents think that the appointment of a guardian for the children terminates their parental rights, and it does not. A guardian steps in as a substitute parent, but parents' rights to the children remain, as modified by what the guardian determines is appropriate for the care, education, health, safety, and welfare of children. And you'll notice that's listed specifically under need. So often the need box is checked in number 5. The form says no parent is willing or able to provide support, care, etc. The statute talks about willing and able. And so sometimes a parent is very willing but not able to provide parenting for a child or children. In fact, a parent who claims to be willing and able would likely not consent. So when you're planning to prove the need for a guardianship, think in terms of proving both the parent is not willing or is not able. But in fact, to be a parent, they have to be both willing and able. It's just that if either is missing, then a guardian would be appropriate. If an emergency minor guardianship or an immediate emergency minor guardianship has been approved in paragraph number 6, check the box and put in the case number. Item number 7 mentions the parents, provide specific information about them, names, etc., and only check the boxes that apply. Number 8 asks who must be personally served. That topic was discussed earlier in this presentation, as well as number 9, who else must be given notice. Note that in the paragraph that says, unless I get court permission not to, service may be done by mail or some other way likely to give notice. You may need court approval to try something such as an email or an Instagram or some other way, but it can be available with the court's permission. But the statute specifically says that mail is authorized. Let's move to number 13. Notice one needs to put in the name of each of the parents. Should a parent be deceased, just put in the name and in parentheses after the name, put in deceased. Number 14 has a chart on page 6 to be filled out. And in number 16, where there is another case involving the child, perhaps a dependency, perhaps an emergency minor guardianship, fill in the appropriate boxes. Moving to number 17, should the child have a tribal heritage, then the Indian Child Welfare Act applies, as well as the Washington State Indian Child Welfare Act. Check the appropriate box and follow the instructions. Number 18 talks about jurisdiction over Indian children, and the phrase Indian is statutory. People might be inclined to say, no, that should read Native American, but in fact, the word Indian is based on statute. Number 19 is jurisdiction over the children, and that is typically non-Indian children. Parents' visitation is worth looking at because in some instances, a petitioner might want to complete a parenting plan indicating which children or which child visits which parents and when and under what terms. Number 21 is decision-making authority, and the difference between 21 and 22 is that the guardian can decide and the parents can decide if you indicate in the right column which category of assistance a guardian could use. But keep in mind that if one parent is incarcerated, they can't easily be contacted about school issues or healthcare issues or any of the other major decisions in a child's life. So typically, the guardian decides in the categories on the page, and in 22, the parents can have access to school and educational and healthcare and other records without impairing the guardian's ability to make decisions. Number 23 refers to child support, basically, and if TANF, that is Temporary Aid to Needy Families, has been received by a child at any time, then the Department of Social and Health Services has a financial interest. In Spokane County, that department is represented by the Spokane County Prosecutor's Office in the Spokane County Courthouse on the second floor across from the Family Law Center. They should be contacted if the child or children has received TANF. Number 24 is really talking about property the children own or have a right to. And the first box would be none if it's only their clothing and personal items and documents. However, Should the child receive a disability benefit from the state or federal, or even from a parent, or public assistance, or child support, that should be listed on the lines provided on the form for paragraph 24. Number 26 talks about who pays associated fees and costs. Finally, speaking to the petitioner now, be sure you sign and date and print your name and provide contact information on page 12 of 13. Notice that you are declaring under penalty of perjury that the above facts in this form are true, so double check to be sure they are accurate. If you're not sure, contact the Spokane County Bar Association Volunteer Lawyer Program and ask for the assistance of a trained individual to guide you through some of your doubts. And remember, should the parents agree to a minor guardianship, they complete the bottom of page 12 and page 13. One caution about providing personal information on this document, such as the phone numbers, is that this is a public document after it is filed, and the phone number would be available to the public, as well as the email address. However, the courts need some way to reach parties. You may recall that toward the beginning of this presentation, I mentioned the value of completing findings and order in pencil at the same time you completed the minor guardianship petition. And the reason is that should a parent not respond to the summons after they were served, the court can default that parent without their ever participating in this process. In order to default one or both parents, the findings and order must precisely match the minor guardianship petition. You can't make even a small change and decide that something such as hours of visitation or a term of some sort would be better. If it's in the petition, it needs to go in the findings and order without change in order to accomplish a default. The third form is found on the bottom half of page 1 of 4, the third item under minor guardianship. It's called Declaration Explaining the Reasons for Guardianship Petition, GDN 103. This is the place to lay out the facts and the details that support your petition and provide evidence that the parents, both parents, are not willing or not able to provide care and support for the child or children. Number 4 of the forms that we are working through here is the one noted above what we've called number 3, which is the notice of hearing about a minor guardianship petition, GDN M101. The next document is the sealed CPS records cover sheet, Form GDN M as in Mike 406, which is handed in to the judicial assistant of the court of the judge that was assigned to the case, along with the motion and order directing DCYF to release CPS information. So those forms are given to the judicial assistant. You will not see the CPS report. It is filed by the judicial assistant when it's returned from the CPS office and would only be available if the case proceeds to a hearing. The next part of this process is to print the criminal history record cover sheet. Remember to write the county in the blank at the top of the form page, County of Spokane. Remember to put in the court file number, and then follow the instructions on the checklist. Every individual who is 16 years of age or older, including the petitioner, must have a background check performed by the Washington State Patrol, and the instructions are on the minor guardianship checklist. The next form, disclosure of guardian or conservator, GDN ALL002, pertaining to bankruptcy or criminal history records. And then sometime during this process of filling out forms and going to court, each guardian is required to take guardianship training, which is available through www.courts.wa.gov/guardian portal. That directs a person to the fairly short video guardianship training program, which a guardian will need to complete. After you complete the approximately hour-long course, print the declaration of completion of guardian training and put it in your file folder of forms completed and ready to be filed. Continuing with the general documents needed listed on page 104 of the Minor Guardianship Checklist, you'll see that I have written in a box for a birth certificate. That is now being required to confirm that the parent who is consenting or is being served is the parent whose name is on the birth certificate. Let's talk now about service. The minimum documents required to serve in this matter, in a request for a petition for a full guardianship, are the summons, the minor guardianship petition, and the declaration explaining the reasons for minor guardianship petition, as well as the order setting a hearing date. I encourage individuals to use proof of personal service form GDN ALL007. Be sure to check each box of the 4 forms that are going to be served. After the summons and petition and declaration are filed, there should be a filing date stamp in the upper right-hand corner. Make copies of those 3 documents, one for each individual who's being served. So, one for the mother, one for the father. If the child is 12 years of age or older, one for the child, and then separately mail to each of the grandparents these documents and complete a proof of service by mailing, which is a separate form. Regarding what I just said about grandparents, turn to page 4 of 4 of the instructions and checklist. In the middle of the page, it says, notice of hearing and petition is required to be sent via mail to. The first one is any adult with primary care and custody of the minors who is not a parent, guardian, or person with non-parental custody. That may not apply in this situation. Look further down, though. Each grandparent and adult sibling of the minors. Any other person the court may determine needs to be notified. And while we're talking about notices, there's a paragraph at the end of that, page 4, talking about what information must be provided to the minor. At the minimum, the minor needs to be given a statement which says they have the right to request appointment of an attorney or object to the appointment of a guardian. They have a right to a description of the nature, purpose, and consequences of appointment of a guardian. They have a notice of all rights retained by the minor, including the right to request counsel, right to attend hearings, and the right to participate, and especially to communicate with the court. The way they would communicate with the court would be to look at the second page of the summons, which has the court's name and address. Minor also is entitled to know whether the court has entered any order limiting information served upon the minors. For younger children, typically the declaration regarding need for guardianship is not provided to them. And the minor may ask the court to reconsider the court order at any time. And then, lastly, how the minor can respond to the petition, which essentially is the instruction on the summons on page 2, probably with a little clarification that the minor can write a letter to the court. Phone calls are not recommended. The Minor Guardianship Act in Washington State requires that a court visitor be appointed for children between the ages of 12, 13, 14, 15, 16, 17, where a minor guardianship petition has been filed to appoint a guardian for those children. That means that the court must name an individual, typically someone already on a court visitor authorized list, to talk to the parents and talk to the minor and determine what the preferences of them are, especially the minor. The court visitor makes a report to the court based upon what the visitor has discovered. The court visitor is not a guardian ad litem and does not make recommendations to the court. It is possible a parent might object to the creation of a guardianship for a minor. If so, notice on page 2 of 4 that there's a section called Respond to Any Minor Guardianship, and the form in particular is GDN M301. When a parent objects to a minor guardianship, an indigent parent has a right to a court-appointed lawyer, but needs to make that request in writing in the form of a motion, GDN ALL021, and obtain the judge's signature for an order appointing a lawyer, GDN ALL022. The financial declaration page, FLALL Family 131, is intended to support the motion, which is to appoint a lawyer for individuals who can't afford one. Should either parent have received temporary aid to needy families paid for the minor child, that is, TANF loan essentially, Spokane County Courthouse on the second floor arranges for administrative orders or court orders regarding repayment of that TANF payment. Let's cover some of the other forms that are necessary. Further down on the page, close to the bottom, you'll see a minor guardianship findings and order, GDN M105. My suggestion is that you complete it in pencil, copying information from the minor guardianship petition, GDN M104. I have seen quite a few clients who arrive to have final forms to be signed by a judge and filed with a clerk and not have a copy of the petition, and then have to go to the county clerk's office and pay for a copy so that they can copy the information onto the findings and order. This may save you some time by doing it in pencil. At the same time, you complete the petition. A point worth mentioning is that in the minor guardianship findings and order, GDN M105, on page 1, paragraph 1, check the box which says summarize the guardianship order below. Under number 1, put the child's name in. If there are some other children, put their names in. And then the date the letters expire is the day 18 years after the child's birth date. For example, if the child, the minor, was born January 1, 2020, then letters expire January 1, 2038. When a court proceeding is scheduled after the filing of the summons and petition for a full guardianship, it is set for a status conference, usually 60 days later, to allow the petitioner time to complete necessary forms, obtain necessary information, complete service of process on the parents and mailings to other individuals. Currently, the status conference is designed to give the petitioner, and in fact the parents also, an opportunity to appear and discuss what progress is being made and where the objections are, if there are any, to this. Sometimes at status conferences, the parents appear, have no objection to the pencil copy of the findings and order and complete them in ink, have the parents sign, and present them to the court for signature, at which time the findings and order will be signed and letters of guardianship will be issued, although sometimes it takes about a week for those letters to be actually received by the guardian. And then you can file the acceptance of appointment. Currently, the Spokane County Bar Association Volunteer Lawyer Program has trained individuals to assist petitioners for minor guardianships by answering their questions and reviewing their forms. So in conclusion, what we have done is provided an orientation for the process, procedures, and forms to apply for or petition for either an emergency minor guardianship or an immediate emergency guardianship and a regular guardianship. Just as a reminder, an emergency guardianship is intended simply to provide some time for the full minor guardianship process to be completed. It is not appropriate to obtain an emergency minor guardianship and not file a full guardianship. In fact, after a while, the courts will simply dismiss the emergency minor guardianship for failure to proceed further. The information I provided is current as of the end of November 2023. As I said earlier, rules change, the law may change. I urge you to read the procedural instructions and the checklist. Determine ahead of time which forms you're going to need. Please don't think you have to complete every form in a packet, or that completing all of the forms guarantees a guardianship will be ordered. Couple of other points. Please keep a record of each step you take so that you can see over time that you're making progress. Courts are really concerned about what is in the best interest of the children. Remember, when you look for facts and details, it's current facts and details that will interest the judge, and an explanation for why the petitioner is necessary and appropriate to stand in for the parents. Thank you for your attention to this matter, and stay in touch with the Family Law Center at the County Courthouse for changes to their checklist. I wish you the best with the process. Thank you for your attention to this presentation.